This is English shorthand dictation number 182 and the dictation speed is 140 words per minute. Ready? Start. An international network of media organizations assisted by a network of international civil society organizations broke a story about state surveillance as a part of a series called the Pegasus Project. In India, one of the newspapers reported that the phone numbers of 40 journalists, 2 ministers, 3 opposition leaders, officials, a Supreme Court judge, and business figures were on a list of potential targets for surveillance at different points in the last 4 years. Forensic analysis of mobile phone devices of some individuals indicated the presence of an infection or an attempted hack. If the allegations of widespread surveillance are true, they represent an unacceptable and illegal invasion of the right to privacy, right to liberty, and the right to dignity of all those targeted. The series also throws up deeply disturbing questions about the source of the hack and represents a subversion of India's constitutional democracy. Pegasus has been developed by the Israeli firm NSO. It is a sophisticated technology that can infect a mobile phone, gain access to calls, contacts, passwords, browsing history, microphone, and camera, which can capture offline conversations and even plant evidence. To be sure, the mere presence of a number does not indicate a hack. The list is full of potential targets. Forensic analysis has been limited and also inconclusive in certain cases. The government of India has denied allegations of illegal surveillance and claimed all interceptions are as per law and due process, though it does leave room open to ask if the government of India has purchased Pegasus and deployed it. NSO maintains that it sells the software only to vetted governments for countering terror and crime. It has termed the allegation baseless and claimed that the 50,000 listed numbers may be for other purposes. But its chief executive also said that allegations of misuse were concerning, and if they are true, they violate the relationship of trust with customers, that is, governments. The gravity of the allegations and its implications for Indian democracy are enormous. If the Indian government has done this, it is a betrayal of the constitutional compact with citizens. If another government has done it, it is a cyber attack on its citizens. Either way, there must be a truly independent judicial inquiry to get to the truth and bring to book those responsible for this violation of fundamental rights. It is gratifying to note that the Supreme Court, while indicating its intention to reconsider the sedition provision in the Indian Penal Code, has raised the question as to why Section 124A continues in the statute book even after 75 years of independence. The Chief Justice of India has also pointed to the rampant misuse of the section by the police across the country and reminded the government that it was a legal provision that the colonial regime had used to suppress the freedom movement. The issues flagged by the Chief Justice of India may set the tone for what would be a comprehensive reconsideration of a section that has been frequently and wrongfully used, especially in the last few years, to suppress dissent, criminalize strident political criticism, and taint opponents with the tag of being anti-national. Even though it is often argued that the misuse of a law alone does not render it invalid, there is a special case to strike down Section 124A because of its inherent potential for misuse. There is a pattern of behavior among all regimes that indicate a proclivity to invoke it without examining its applicability to the facts of any case. Recent cases show that sedition is used for suppressing criticism and protests against particular policies and projects of the government, for criminalizing dissenting opinion from human rights activists, lawyers, and journalists, and to settle political scores. It is not to be forgotten that the section was upheld in 1962 by a constitution bench, but the court is now seized of several cases that seek a reconsideration of the 1962 verdict, citing more recent judgments expanding the scope of fundamental rights and doctrines that have been subsequently evolved. The points to be examined in particular are the chilling effect that a law may have on free speech and the vague and overbroad definition of sedition that renders both provocative and innocuous speeches or writings equally liable for prosecution. In 2016, the government itself admitted in Parliament that the definition of sedition is too wide and requires reconsideration. The Law Commission of India also released a consultation paper in 2018 that said, "In a democracy, singing from the same songbook is not a benchmark of patriotism. People should be at liberty to show their affection towards their country in their own way." While issuing fresh guidelines and safeguards is one way of quelling the potential for its misuse, it will be more helpful if Section 124A is struck down altogether. Undoubtedly, trafficking is a pernicious offense, and societies and governments must have zero tolerance for it. And yet, handling the offense of trafficking needs precision, not a sledgehammer. In its current form, the draft bill on trafficking in persons seems to be lacking in nuance, although it is a good attempt to stamp out exploitative trafficking. The bill, which will shortly be introduced in Parliament, aims at preventing and countering trafficking in persons, particularly women and children, to provide for care, protection, and rehabilitation to the victims, while respecting their rights and creating a supportive legal, economic, and social environment for them. This is the bill's second iteration. The first one was passed in the Lok Sabha in 2018, but then meandered into nothingness as it was never introduced in the upper house. Notably, the bill has expanded the area under coverage to include offences taking place not only within India but also outside of the country. It envisages the setting up of anti-trafficking committees at the state and national levels to implement the provisions. In the days when the bill was up in the public domain for comments, civil society activists and legal experts have criticized various provisions and submitted that an overzealous approach would blur the nuances and an understanding of the contributing factors, including vicious poverty, debt, lack of opportunity, and development schemes missing their mark. There has been vociferous opposition over the key aspect of handing over investigation in trafficking crimes to the National Investigation Agency, both by those who believe that it would burden the already stressed unit further and those arguing that this move would be an attack on federalism by removing local enforcement agencies out of the picture. Another key criticism of the bill has been its broad definitions of victims, smacking of refusal to consider consensual sexual activity for commerce. This would only land up criminalizing sex work and victimization of the exploited. Bringing pornography into the definition of sexual exploitation would not allow even for any adult consumption of non-exploitative consensual material. Reporting of offences has been made mandatory with penalties for non-reporting, but those with an understanding of the tortuous processes point to the fact that victims often do not want a complaint to be recorded. The mention of the death penalty for various forms of aggravated trafficking offences needs to be flagged too. The government would do well to scan and incorporate the response to its bill in order to ensure that the fence does not eat the crop. While sexual exploitation and trafficking can be ghastly crimes invoking public horror, it would be equally horrific if the state does not employ a wholesome approach. The latest inflation data based on retail and wholesale prices are yet again flashing cautionary signals as spiraling costs continue to dog the pandemic-hit economy. Inflation at the retail level was largely propelled by sharp increases in key food item prices, including oils and fats, which surged almost 35% from a year earlier, and pulses, which climbed 10% from June 2020. Fuel inflation, which excludes petrol and diesel, surged to a record 13% in June, driven by LPG, kerosene, and firewood. LPG and kerosene prices have also registered increases so far in July. Transport costs remain persistently high as both petrol and diesel prices continue to rise. With global crude oil trending higher, the unabated rise in domestic transportation costs is bound to reflect in retail prices of farm produce and products shipped from factories.